shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the April 15th, 2026 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Rachel Hershfang. To my left, Justice Robin Toone, and I'm Justice Eric Neyman. We will be your panel this morning. Usual appeals court rules are in effect. Each side has 15 minutes to make their presentation. There is no rebuttal. We go by the clock. Each side, as I said, has 15 minutes, except for one case where additional time is being provided. When the clock goes red, when the red light comes on, please stop your argument. If the panel wishes to give you more time, we will do so. Finally, you will see on occasion the judges looking at their laptops or iPads. I assure you we're not looking at the Bruins or Celtics scores. Rather, we have the entire record in front of us. We are checking the record, we are checking the cases, and we are checking facts in the law in real time. So with that in mind, let me see if there's any further business. Seeing none, we will call our case, docket 25P606, Commonwealth v. Carvalo. And we will hear first from, I believe, from ADA Mark. Good to see you, sir.
May it please the court, David Mark for the Commonwealth. In this case, the defendant was a driver of a dump truck. He was working at night. To fuel the truck, he needs to raise the dumpster. He did so, fueled the truck, but got back into it having neglected to lower the dumpster. He then drove off and ultimately drove into the Route 24 overpass, considerably damaging both the overpass and the truck. The defendant moved to dismiss. The motion itself doesn't really stay to ground, but at the...
It's clear it's a De Benedetto motion, right?
Sorry?
It's clear it's a De Benedetto motion.
Oh, yes, absolutely. No, I have no dispute about that, Your Honor. The specific ground on which the defendant was arguing that the motion to dismiss should be granted emerged at the brief hearing on the motion. And the defendant's theory was that 24(2)A really only encompasses manner of operation, not the condition of the vehicle.
Can I ask a preliminary question?
Yes.
So this is a De Benedetto motion, so what's relevant here is we are technically reviewing what was before the clerk magistrate who issued the complaint. Is that correct?
It also means this court's review is de novo.
Okay. So what information was before the clerk magistrate? There was the application for complaint.
And the police report.
Something is checked off that mentions the police report. I saw that, so I think, and your brother doesn't seem to disagree with that, but you also reference in your brief at Record Appendix pages 15 and 16 the crash report. Are we certain that the crash report was before the clerk magistrate?
I'm not, and I don't want to check now, but I think we can ignore that. I'm sorry if I made that mistake.
Yeah, I don't know that it's a mistake, but you do reference it in your brief. You cite to RA 15 and 16, which is the crash report.
So either I thought it was appended to the materials that the judge saw, or I made an error. But I think the police report itself will do the job here.
So you would stipulate that you are not relying on the crash report for your analysis here?
Yes.
Okay.
Correct, Your Honor.
Please continue.
I apologize for that. I'm sorry.
No need to apologize. It's unclear from the record, at least in my view.
Right. So, notwithstanding the fact that the review here is de novo, let's start with the defendant's argument, because I think the distinction that the defendant seeks to make cannot be maintained. Our ace in the hole here is Angelo Tedesco Corporation, but even without that, I think the model instructions and indeed common sense and a plain reading of the statutory language gets us where we need to go.
I mean, we can't, the model instructions are supposed to reflect the law, not sort of drive the law. So I guess,
I agree with that.
I know it is kind of the defective condition of the vehicle is cited in there, but we have to sort of go on other authority. So you have Angelo Tedesco, and then what else would you rely on besides that? That's a vehicular homicide case, right? Just the same tort standard, but
Correct.
different statute, right?
Yes. So there's a surprising dearth of law on this particular fact pattern, and I think Angelo Tedesco is probably the case that gets us closest because it's a pure condition of the vehicle case. Really all the others that I found in Massachusetts, even some that have rather helpful language, are manner of operation cases.
Right. Can I ask you about that case? So it's an interesting case. That's essentially a police officer, I guess, is killed because a dump truck, again, reverses into him, and there's no rear
It's the backup
backup alarm.
beeper.
Right. And you know, in vehicular homicide cases, you have sort of a causation of the death, right? But here, under the negligent operation statute, you really don't have to have an actual injury. You don't have to have a crash at all, right?
Right. No.
The elements are negligent operation and posing a risk to the lives and safety of the public.
Right.
But I guess that opens the door, like, you could have a lot of liability in the statute, right? There's all sorts of things that people might do driving their cars that are negligent and arguably pose a risk to the public, even if accidents don't occur. So I'm trying to, you know, like, would it be a criminal act to sort of drive down the highway with a bunch of snow on your car, because that potentially that's negligent, and that potentially could, you know, endanger someone behind you if the snow drives off? What's the limiting principle here, so we're not getting into sort of every act of negligence on the highway?
Your Honor, it's funny that you choose that example because that's one we argued in the moot court.
Okay.
But I mean, my reaction to that is I think that would qualify if there's a sufficiently, it becomes a jury question, but we're really in a probable cause universe here, right? If there's an enormous pile of snow on your car and you're driving on the highway and it just dumps on the car behind you that now is blinded and runs off the road, I think that's a good condition of the vehicle case where you were inattentive to the condition of your vehicle and drove it while it was in this hazardous condition on the road.
So anyone who's driving with half foot of snow on their car is arguably guilty of a crime?
No, at some point, not enough. If it's 3 inches, maybe it's just kind of a dusting. If it's a lot, maybe you know, the snow is hardened overnight, so you have no expectation it would actually break free and come off. Again, it becomes a jury question, but we're in a probable cause standard here.
What about, you know, it's a rite of passage here in Boston for students to rent U-Hauls when they're moving in and drive on Storrow Avenue and hit the, are those students all, are they all committing crimes?
Yes.
Okay.
So, I mean, if you've got your mattress, you know, on the roof and you have not, you know, tied it down sufficiently tightly, and that comes off and drops into the path of another car, it causes an accident, or just drops off and could cause such an accident because
Seems like there's a lot of criminals on the roads under your interpretation.
Well, I mean, it is Massachusetts.
So the answer is yes, potentially, but you know, most people get away with it. If this driver had not had a bridge between him and his destination, he would have gotten out of the car and oh, goodness, I forgot to lower the dumpster.
Yeah.
So that does kind of, if I can kind of jump sideways a little from Justice Toone's question, that does lead to another distinction between this case and the Angelo Tedesco case, which is, it may be a distinction without a difference legally, but in the Tedesco case, the driver knew that his beeper wasn't working. And here, I think there's no allegation that the operator was aware that he had forgotten.
You're absolutely correct, Your Honor.
Does that matter?
Well, so my argument is no, and really at bottom it's this. How can inattention not be negligence, right? If the difference between Angelo Tedesco in this case is just sheer inattention, you know, look at the very definition of what negligence is. I don't think that helps the defendant.
What about with the snow? You know, we were talking about how much snow is negligent. What if you just are unaware that there's, I don't know how you get into your car without knowing there's snow on the roof, but let's assume you have some kind of limited vision, you know.
I think you're okay then, in terms of your criminal liability. If I mean, there has to be a want of due care, So if you have no reason to suspect or to look or to check, then it's just an unfortunate accident. There may be something in the condition of your car that you had no reason, some part of it has rusted and has now come loose. I don't think you're under the statute then when something breaks loose and your muffler falls off and rolls into the road and causes an accident.
So with respect to everybody who gets starroed on or about September 1st of every year, is the negligence in their having entered the roadway while ignoring the 500,000 signs on the way that say, you know, minimum height is X bridges, and in not knowing how high their rental truck is?
If I understand your hypothetical perfectly, that's exactly right. I mean, that is unquestionably negligent operation. You have an obligation not to drive your truck into bridges. Right?
So let's get back to Justice Toone's original question, which is, how would you articulate the limiting principles here? You seem to be arguing there sort of are none, and you deal with that when you get to trial.
No, I wouldn't say that. I'm only arguing that the probable cause standard is not the reasonable doubt standard, and that gives you some leeway. It is certainly possible to imagine a case that meets the probable cause standard and then loses a trial or even is directed out at trial, right, under the more rigorous standard. So, but it's not no standard, it's just a recognition that there are some cases where we're talking about a kind of gradation of risk, and at some point a fact finder or a reviewing court would find it's dropped below. But I don't know that you can make a kind of clear cut on the snow example. If there's 3 feet of snow on the car, you probably shouldn't be driving it without brushing it off, right? Especially if you know you're going on the highway. If it's 6 inches, you know, that's not likely to cause a blinding tsunami to the person behind you.
I guess the problem I have with your position, or the concern I have about it, is the fact that in this particular, normally negligence in tort actions, there's some injury that occurred and you're trying to sort of figure out who's responsible for the injury, right? But here you actually don't need to have injury, you just need to have there might be a risk, there might be a danger. So I'm just trying to understand, like, what kind of defects to cars don't pose some kind of safety risk to the public? Just give you an example. I pull you over for speeding. You're going 10 miles over the speed limit. I pull you over and I notice like your right hand mirror is broken, so you can't have your turn signal indicator doesn't work. And I say, oh, I'm going to cite you for negligent operation because you're driving a defective car, and that poses a risk to the public. So it just seems like we're opening the door to a lot of liability here that may not have been intended.
Your Honor, I think your argument here is with the legislature, because the statute is drafted and the standard is just tort-style negligence, and a consequence that the lives or safety of the public might be endangered. It doesn't require that anyone actually be put in danger. To take on your hypothetical, there's a somewhat more alarming case in Massachusetts where someone her passenger was actually leaning out of the window of the car, and the court noted this blocked, the side view mirror and any view of the road on that side. So that's a more extreme example. Does the loss of a mirror, is it enough? That's not the case in front of us. I mean, I don't want to dodge it, but I think, I wonder whether that person would be cited for one thing.
I don't think there even were right side view mirrors when I learned to drive.
No, that's true. I remember that as well. It's a comparatively modern thing that you have mirrors on both sides.
Okay, well, but I guess there's a lot of examples of things in one's vehicle that could be defective, that could pose a safety risk.
I agree,
but I would question whether the legislature actually intended to be opening the door to criminal liability in all those cases, even though many aspects.
Well, my extreme, if you will, position here could be wrong, and yet the Commonwealth should still win this case because of the nature of the sort of obvious nature of the risk posed by the negligence.
We'll say a little bit more about that. What would be the standard that would distinguish this case from more bread and butter, I don't know. I'm trying to think of a
Yeah,
less-
so how would you say
my
it?
turn signal's not working versus this case where the defendant allegedly runs his truck into an overpass.
with the dumpster raise is now more than 15 feet high, and he's driving it on the highway. I mean, he knows where he's going. So the likelihood that he would pass under a bridge at some point is reasonably high, and the danger is obvious, right? I mean, the collision that happened here illustrates that beautifully, because the truck broke apart and parts of the bridge broke off when this, probably 20,000 plus pound vehicle hit the bridge.
So final question for me. Assume the exact same fact pattern. Defendant fills his gas tank, lifts the back of the truck, so it's 15 feet high, leaves. He's going down the road for miles and miles, doesn't hit anything, but police officer sees him and stops him, and he's charged for operating to endanger.
Absolutely. I'm completely comfortable with that. It's the same case, right? The fact that you don't hit the bridge doesn't mean that it wasn't negligent to operate the vehicle in that manner.
Let's assume there are no bridges within 20 miles.
So it becomes a slightly harder question. I wonder whether the vehicle is as controllable in a condition where, there must be an enormous amount of wind. So again, it may be evident that it's, I think you might still meet the probable cause standard there, even if the driver knew there was no bridge between, where he started and his destination.
Okay.
I just want to thank you for your brief, which was an excellent read.
Thank you very much, Your Honor.
Okay. Seeing no further questions, thank you. And Attorney Solomon, nice to see you. Now, you did not submit a brief in this case. Please go to the podium. Sorry. Because you did not submit a brief, our rules are you may not make a presentation, but you may answer questions if the court has any. Fortunately for you, I do have a couple of questions, or perhaps unfortunately. You're probably going to want to put the microphone back where it was because it needs to both pick up your voice and record you.
Okay, Judge.
So you don't dispute that the police report here was properly before the clerk magistrate, correct?
No, Judge, I don't dispute that at all.
Okay. So let me ask you this question. Your argument, as I understand it, is that the defendant wasn't speeding or driving erratically. It was just a condition, so therefore the statute doesn't apply.
Yes, Judge.
So that leads to this hypothetical for me. Suppose a defendant, I don't care, is driving a pickup truck and the road is 20 feet wide. And in the back of the truck, he puts a 45-foot steel rod perpendicular. So it goes across both lanes, across the highway, into the median. And it strikes other cars, it strikes pedestrians, and it takes down a lamppost. Are you still making the same argument, no probable cause for operating to endanger because it's a condition?
Not exactly, Judge. No, I think this is an affirmative action. This is something that's, if the
When you say this is an affirmative action, what are you talking about?
the example that you just gave, if the defendant...
Because the person put the rod in the back of the truck?
Exactly.
Didn't the person here lift the back of the truck in order to get gas? Isn't that an affirmative action?
He did, Judge, but he activated a specific component of the dump truck. I think if somebody is adding additional materials to their car or truck, to me, that's a distinguishing factor. I think everybody has to take great care, just a common sense application. We all know if we start loading items into the back of a pickup truck, there's certainly a possibility, if they're not secured.
You're making a distinction that if it's something that is part of the truck that is adjusted, that can't be operating negligently so as to endanger?
In that particular instance, yes.
Okay, so what if he opens the hood of the truck to check the oil and starts driving away and the hood's entirely in front of him, but he keeps driving? That's just an adjustment to the truck, no operating to endanger?
It is, Judge. It's largely dependent on the circumstances. I think if there's no other erratic operation, because to me, and I don't disagree with Justice Toone when he says, look, the jury instructions are really just an explanation of the statute. I think the statute really focuses on the defendant's driving. I think the language is clear. And we all know an accident in and of itself doesn't necessarily suggest negligence. Accidents happen. That's why I think driving prior to the accident is the most important consideration, the manner of operation. If somebody makes an honest mistake, again, these things happen. I don't necessarily think we can attribute that to negligence. I would also point out, Judge, there is a big distinction between a criminal act, specifically the negligent operation statute, and a civil suit. In this case, in the case that we have before us, I think the defendant was absolutely negligent. No question about it. What I don't think he was doing was driving negligently because of all the things I point out in my initial motion to dismiss. There's no suggestion he was speeding or swerving or weaving or jerking his car from left to right. There's no evidence at all that he was physically or mentally impaired or incapable of operating the car safely. He made a mistake. These things happen. That's why I think it's so important to look at the behavior prior to the accident. And just for what it's worth,
I'm going to have to stop you right there.
Sure, Judge.
Well, I give you another hypothetical. Someone's driving a truck with a lot of large metal objects, and they're not kind of fastened down properly, and going, down Mass Pike at 70 miles per hour, and suddenly all the metal flies out, and it's a disaster, right? Is that even if the driver was driving perfectly, is that not sort of potential negligent operation?
Judge, respectfully, based on my prior rationale, I don't think it is.
Yeah.
I think it's certainly negligent. Is it negligent operation without any additional evidence of erratic or unsafe operation? I don't think it is.
What about the case, I think your brother, I think it's Kaplan, where the driver was found liable because the passenger's torso was out, the passenger was like leaning out the car, the torso, and screaming, and they couldn't, and the driver couldn't actually see through the side window because of that. The driver's still driving perfectly fine, but kind of the condition in the car amounted to negligent operation. Is that sort of distinguishable?
I will tell you, Judge, and I certainly admit I'm not familiar with the Kaplan case. I am familiar with the Toscano case.
Yeah.
That seems to be
Tedesco?
I'm sorry?
Tedesco?
Tedesco, Judge. My apologies. That seems to be what the Commonwealth is relying on. And to be fair, I don't think it's an apples-to-apples comparison. The court certainly pointed out, and I agree, that's a motor vehicle homicide case.
Right, but the case stands for the broader proposition, I think, that we apply the civil negligence the same civil negligence standard when negligence is an element of a criminal offense, at least in the motor vehicle context. Do you dispute that?
No, I don't. I think in motor vehicle homicide cases, injuries are certainly a relevant factor to be considered in the negligence context, and rightfully so. When you have somebody who's, unfortunately, who died, there should be greater considerations. But again, the distinguishing thing about that case and this one, and the court did point that out, that was a case where the driver knew that there were certain safety measures that were defective. He knew it. He decided to get into that truck anyway and back up in a crowded construction zone, no less. So again, that's a very big distinction from this case where the guy just made a mistake. He just forgot to lower a certain portion of his car. Now, one of the things I also think is important to note, thank God nobody got hurt. There was no accident. This happened at 3 o'clock in the morning. Presumably, there's not one other person on the road. I think we can all make an inference. If this happened at 7 or 8, and any good Samaritan or any motorist was on the road at the time that a dump truck is approaching a bridge with its bed raised 15 feet in the air, I think again, we can all make the inference that somebody is going to say something. Sir, you're about to get into an accident. Lower your bed before you go under that bridge. Or, sir, your bed is extended. You might want to take a look at that. Because there was nobody else on the road, unfortunately, this accident happened. But again, Judge, my entire
But isn't that
argument
worse
is-
for you? I mean, in the negligence context, the question is not whether anyone was injured, but whether anyone could have been injured.
I agree.
And because horns are less articulate than you just were, it's difficult to imagine how another motorist might have quickly conveyed the relevant information, and then it would have endangered everyone on the road.
I do understand.
And on 24, which is a pretty busy morning road, right?
You're absolutely right, Judge. And that's why I said I do think there is a distinction between the crime of negligent operation and a civil suit for negligence. I absolutely think this is negligence. This is negligent. It's a much more encompassing definition. Any act or omission could be considered negligence.
Do you have a case that says that the standard is different for civil versus criminal, for negligence as defined in the civil versus criminal law?
I don't have any controlling authority. No.
Do you have thoughts on what, setting aside whether it was negligent or not, do you have thoughts on what the standard should be to assess whether conduct might endanger the lives and safety of the public?
I'm sorry, Judge, just specifically in regard to the negligent operation charge?
Yeah. Well, it's negligent operation. The third element requires negligent operation that might endanger the lives or safety of the public. And so I'm just trying to, you seem to suggest, well, that part might be satisfied under the complaint application here. But I guess just do you have thoughts about what qualifies as might endangering the safety of the public and what doesn't?
I do. And again, to your earlier point, and I don't disagree, the jury instructions are really just a roadmap to how the statute can be interpreted.
Yeah.
I think the jury instructions certainly lay out. The Commonwealth has to prove that the defendant drove negligently. So the manner of operation is paramount. How he was driving. Was he driving? Go ahead, Judge.
Are you arguing that the model jury instructions are incorrect as a matter of law?
Not at all.
Okay.
Not at all. I'm just pointing out if Justice Toone is asking me to define or maybe illustrate particular behavior that I think is negligent, I think it's represented here. How he drove, that's the consideration. Not the fact that there was an accident. I know there was, but an accident in and of itself isn't evidence of any.
Well, it's not
operation.
required. You don't have to have an accident under the negligent operation statute,
true.
right? Which makes it a little bit different from the typical tort case where you have to have some kind of harm.
That's true. I don't
So
disagree
I
with
guess I'm just trying to sort of, is there any kind of negligent driving that wouldn't arguably endanger the lives and safety of the public?
Is there any type of negligent driving that wouldn't? I mean, I guess purely in a speculative way, it all could.
Yeah.
Depending, again, who else is on the road. There's a number of conditions, a number of factors that the court can consider. But I think if you're driving negligently, if your manner of operation is unsafe or dangerous, then to me it's all encompassing. But that's not what we have here in my opinion.
Anything further?
No.
Seeing no further questions, thank you both. Well argued. This is an interesting case, and the case is submitted. Calling our next case, docket 25P578, Commonwealth v. Hickey.
Good morning.
Good morning,
May it
counsel.
please the court, Kara Shayette for John Hickey. So the only question on appeal is the lawfulness of the restitution order. Before I get to the substantive challenges to that, the Commonwealth argues that the appeal is moot. I thoroughly brief this in my reply, but there are 3 quick points I wanted to make on that occurred to me this week. One is, I'd actually forgotten this, apparently my appointment in this case as appellate counsel is unusual. Turns out CPCS typically doesn't appoint appellate counsel to appeal to challenge a restitution order if that's not paired with a direct appeal from a conviction, whether that's a trial or a plea. And that just increases the possibility that this kind of issue, if I'm right that it's much more systemic and common, based on the colloquy and what the judge said, that it's much more likely that this could, repeat and evade review because an indigent defendant isn't going to do this on their own, so it never comes here. And did you have
I do, but go ahead, finish your thought.
well, just that on that, again, if I'm right, I'd really urge the court to publish its decision, because otherwise a decision out of this court only affects the parties, and I don't think trial counsels are looking at unpublished decisions, and judges aren't bound to apply them in other cases. And a third, sort of a separate issue, and I was chatting with the ADA this morning, that I think in my reply brief, I cited that Rhode Island Supreme Court case, and I think I actually sort of undersold it. What that says is that the restitution order ripens to a civil judgment. It's not even clear to me that the victim would have to litigate the amount of claimed losses.
I think you're absolutely right about that in Rhode Island, under a Rhode Island statute. I found no similar statute in Massachusetts, and I found, I'm a terrible researcher, so take this with a grain of salt, but I found in fact, Massachusetts case law tending to indicate to me actually that a restitution order affirmatively does not have the civil preclusive is the wrong word, but that a criminal restitution order doesn't operate as an adjudication of rights in a civil case in Massachusetts the way it does in Rhode Island and in some other states that have statutes similar to Rhode Island's, including Colorado. And
It's still, honestly, I've never tried to litigate this kind of civil case, but certainly I would think that the victim has the wind at their sails when they go into a civil court and try to prove this. And it certainly would seem to me that it would have some evidentiary value.
Right, but that's, just to follow up on Justice Hershfang's point, I thought that the court in Martinez, which I'm familiar with because I argued it for the Commonwealth, but that they actually said, unlike other states, it doesn't ripen in the sense, like you can't actually bring a civil case premised just on the restitution order in a criminal case. Now, that doesn't mean that resolves the other arguments you're making with preclusive effect, but I think that's a well established. Do you disagree with that? Or?
And I'm sorry if I missed that. And I remember Martinez talking about, because that was the one where they were talking about, was it the Colorado case where,
Nelson v.
or
Colorado,
the
yes.
Supreme Court case, that's right.
Yeah.
And so I may have missed that. So that may be true. I still don't know what would happen when like the victim in this case, were to go into civil court. And I don't think that if it's an unlawful restitution order, that should stay on the books.
So there's a difference between mootness and capable of repetition yet evading review. That second part, repetition yet evading review, gives us discretionary authority, and we may or may not exercise that. But first, we need to address mootness. It seems to me that, at least when you drafted your brief, which I believe you submitted on October 2nd of 2025, right, you asked that we vacate the restitution obligation and that the probation should be discharged. And then the docket entry in the lower court on November 7th, 2025, that very thing happened.
Well, but his obligation to pay, but the fact that there's this $3,900, $4,000 restitution order that was issued, it was his requirement to pay. The criminal restitution in the criminal court certainly was vacated, but I don't think that.
But my point is that is what was sought in this appeal. The court has effectuated the remedy that you sought.
I disagree because the order still, he wasn't going to be required by a criminal court to pay it as a condition of probation. But I honestly.
When you say Hickey's restitution obligation should be vacated in your brief, you also, by that, included any potential civil suit that would follow?
No, and I apologize if my sort of conclusion, the relief the way I articulate it was, I don't think that that's necessarily reflective of the brief as a whole, because I still think there's a question of this $4,000 obligation that's on the docket that was adjudicated at the July 2024 restitution hearing. So I agree that the criminal court has said, you're indigent, you don't have to pay. But in terms of whether there's this potential collateral consequence, even if it doesn't have the preclusive effect, that there's some burden on my client from
What would the
having-
statute of limitations be on a civil case for?
Whether it's 3 years, I mean, so it could be up this summer. I actually didn't look at that. I don't know if it's 3 or 6 for that kind of I honestly don't know.
As I read the November 2025 order, the judge discharged the defendant's obligation to pay restitution.
That's right.
And you're asking that the underlying order be vacated. What's the difference between those two things?
And I'm sorry, and I hate when I start, if I'm repeating myself, I'm always, that I'm not answering a question, because I think the difference, again, is the difference between you have to pay or you're potentially at risk of violating probation, which of course has now been discharged, versus there's a finding that the victim's economic losses were $4,000, and then what civil liability does that?
I don't see what collateral consequences there are from an order of restitution that's discharged. But let's skip over that. Let's go to the you might have a stronger argument with preclusion, but that's kind of a funny issue because, as I understand it, probation orders are kind of done on a little bit of a looser record. Like here, they looked at the police report, allegations in the police report, right? And it's a little more of a casual proceeding, I guess, than you would have in a civil lawsuit. So, is there really an argument that the judge's order finding the defendant owed this much in restitution would be preclusion in a civil case? I
think you persuaded me that it wouldn't have preclusive effect, but it might have evidentiary value. And this is a restitution hearing is still, the Commonwealth has a burden, a preponderance burden, not reasonable doubt. But there's,
What evidentiary value? Like someone could introduce the order as evidence? Or?
I honestly don't know, because especially, if we're talking loosey-goosey, if this were in small claims court of all the loosey-goosey proceedings, and so if a victim comes in, I was the victim of a crime, a judge found, here's the order that I'm owed $4,000, I wasn't able to collect, I want to proceed. And again, it may not be the strongest. I do think the capable of repetition and yet evading review does bring me into the discretionary realm. And again,
I just want to understand the shift I think I just heard you making. Are you saying, I don't want to talk anymore about whether it's moot, unspoken subtext, probably it's moot, but let's talk about capable of repetition as evading review?
Well, if I'm not, I hear the challenges to my argument that it had any preclusive effect. Again, I just think that if it's an unlawful order in all the ways that I argue that it is, that the victim shouldn't have the benefit of an unlawful order, and whatever happens, that my client should be this. And if I can sort of back up just to think in terms of what Henry requires, if it were done properly, it's victim's proven economic losses plus defendant's ability to pay equals maybe 0, in which case there wouldn't have been any restitution order at all.
So, but for the procedural violation that has been conceded by the Commonwealth in terms of the order of operations, that the Henry hearing didn't happen timely and that this order should not have been entered absent one, that was a terrible attempt at a beginning of a sentence. But absent all, I think your argument is, if it weren't for all of that mess, this order would not have ever come into existence. And now a judge has determined that this order should never have come into existence. And so my client isn't getting what my client deserves until the situation is as if the order never came into existence.
Yes, the only qualification to make to that is that the November 7th determination was a sort of current circumstances, right? And
So not nunc pro tunc to whenever the Henry hearing
exactly
should have
right.
happened.
And just on that, the only time the phrase Henry hearing ought to be used is for a change of circumstance after a lawful restitution order is entered in the first place. You know, the judge is referring to, in this case, Henry hearing before an order of restitution has even been issued. It's not that, it's just a restitution order where both considerations have to be considered before any order is made in the first instance.
What's so tricky in my mind is that the November hearing wasn't, it effectively fixed the Henry problem by saying, okay, I'm discharging the restitution obligation. But your argument is that the Henry violation, I guess, in July means that the restitution order should never have been granted at all, right? But it does seem like it's a little bit, like the Henry problem doesn't really go to the merits of whether or not the defendant owed restitution. It's you know, I totally take your point that you need to, Henry says you got to do it at the same time, and therefore it wouldn't have happened. But it does seem like the violation here is a little bit distinct from what you're trying to undo now.
Well, but there's also the fact that the probation should have been up last May, right? So there were two unlawful extensions of his probation. I mean, so there's this really, you know, from start to finish, this was, you know, no notice, no combining the two inquiries as there should have been, you know, no continuance. And I would rarely, I mean, I don't think I've ever argued that the lack of a continuance is a material issue. But here, Faulkner really goes to that, right? If you have a right to notice and you have a right to counsel, if the Commonwealth fails to provide any notice, then the denial of the motion to continue is effectively a denial of counsel. And so there's that. And then we get to the conceded error in terms of not combining these inquiries. And then there's the July 24 extension of probation to service an unlawful order of restitution. And then, in my view, I think that you can absolutely read the January 2025 hearing as a second unlawful extension of probation. And so, again, it goes to that question of whether this court exercises its discretionary opportunity to look at this. If this is what's happening in the district court, my client can't be the only one who suffered from this series of errors. And I just really urge the court to reach the merits. You know, one of the issues in Faulkner that I really wanted to highlight is that, especially if there's that you don't condition the judge's insistence, and the Commonwealth relies on this. Well, he had that morning to look at the paperwork. Why wasn't that enough? He knew in May there was going to be a restitution hearing, but it wasn't until second call that the trial prosecutor offered up any of the paperwork. And Faulkner says that the notice has to be that, I think that where there are scheduled court proceedings, you get some anticipatory notice, that you don't wait until the day of. And so Faulkner really answers this and says it's not, we don't know what an attorney with the proper notice might have done. Then you get to the back end of my brief, you know, the amount and the sufficiency of the evidence to tether these losses to the actual crime. I would, at least the defendant should have had the opportunity to have a trial attorney who had the opportunity to mount all of those kinds of arguments that I've presented in this appeal. So I'm happy if there are any other questions.
Well briefed, well argued.
Thank you very much.
Counsel. Commonwealth.
Good morning, Your Honors. Assistant District Attorney Matthew Padalano on behalf of the Commonwealth. Your Honors, I was trying to think of a way to say this without using an idiom, but at the outset, I just want to say that the Commonwealth really has no horse in this race. essentially, for the reasons I say in my brief, I think this argument this is moot, essentially. I'm happy to go into that. But as far as my position is, I want to help the court reach a conclusion that makes sense given the circumstance, but the Commonwealth is really of the position that whatever the court determines is correct determination is perfectly fine with the Commonwealth.
Well, I mean, it is getting on toward Derby season, so if I were to ask about horses that the Commonwealth might be backing, it does seem to me that this last argument about, in essence, I know this isn't, it's the way I think of it, it's not the law, the process that's due in advance of this hearing. District court practice is a little seat of the pants sometimes, and what has been described to me as having happened in this restitution hearing did not shock me. I wouldn't be surprised if it were relatively common and people just kind of went with it. Does the Commonwealth have a position as to whether it's, what the effect might be if we took counsel up on the invitation to be firmer about what Faulkner really requires and to kind of mandate those sorts of disclosures on a more regular, timely basis?
Sure, and I apologize if I didn't communicate this clearly in my brief. I don't disagree that the discovery owed was somewhat insufficient as far as timing goes. My issue, more plainly, is that what remedy then, given that sort of discovery violation, is the defendant owed, and that takes into account various circumstances, including what could you do if you had more time, right? What sort of investigations might you undertake? What would you do with these records if you had more time to look them through? And the defendant's trial counsel conceded that I couldn't do anything else if I had more time. There would be no other investigations. That would be, I think his phrasing was exactly, I'll concede that, Your Honor. So I don't necessarily disagree if the court wishes to make some sort of published statement that in these restitution hearings, more discovery is owed on a better time frame. My issue is more with the judge's discretion to choose what the remedy is in that context, and here they determined that no remedy was owed.
What about the Henry issue? Do you agree that the judge should have determined ability to pay at the time that the order was imposed?
So I believe the correct order of operations is the victim's damages first, then a Henry hearing, and then once those both have happened, then an order. Whether they need to happen on the same day, I'm not sure, but I do
But no
agree.
order until ability to pay?
Exactly.
So that was an error.
That was an error.
Okay.
Whether or not it was corrected at the later date, that would be sort of my main argument. But frankly, the then third day where the restitution is discharged, again, renders this all somewhat moot. I mean,
Well, okay, so I appreciate your candor on all those points. And so I do wonder if, setting aside our discretion to address the issue, if we think it's capable of repetition yet of any review, it doesn't seem like a terrible argument that the existence of the order is something that could be used against the defendant in a future civil case. That, I don't know if it's issue preclusion or just something that could be introduced as a fact, but it does seem, particularly if this is in small claims court or something like that, something that could be used sort of, well, another judge already said you owed $4,000, right? And just help me with that. Help me, why shouldn't we assume that there's some kind of potential
and
preclusive
I
effect
will,
here?
begin by stating that this is all brought up in a reply brief. I understand that the timing of events makes it hard for it not to have been brought up in a reply brief,
Yeah.
but a amended brief could have been potentially filed and wasn't in this case. So we're essentially left with a 1 or 2 sentence argument on this point.
But you raised mootness and
Understand.
Right, okay.
As far as issue preclusion, I believe that the calculation of damages in a civil context involves many more calculations than it does in a restitution context. It also, our standard for a restitution context is spelled out in the rules of criminal procedure. As far as, I don't have the language right in front of me, but I believe the language is it has to be causally tied to the victim's crimes. I don't believe that that's the same issue that would be before the civil court as far as damages, and for issue preclusion to apply, it has to be identical issues. They can't be very similar issues. That being said, I don't know if a small claims court might play loosey-goosey with that ruling. But it's
It's
hard.
the same, both, in both situations, it's both the preponderance of the evidence determination, right? Under our restitution laws, right? So that's the same.
That is correct. And I do believe you made a point on defendant's argument that the lower evidence should be relevant. I do believe as far as like administrative hearings and things like that go, that the burden of evidence is not relevant for issue preclusion, that you can have, as long as you're going down in burden of proof. So for example, you're going from a criminal context to a civil context, that's issue preclusion, but the other way is not.
Right, but your other point was that there has to be this causal relationship in the criminal context between the crime and the restitution, whereas that may not be required, but that seems to only go to the defendant's point here, because even if there were more ways to establish liability, certainly that itself is a way to establish liability.
I'm
in the
not
civil
sure if
context.
it's necessarily just more, but is actually different.
Right.
And forgive me, I'm not familiar with how civil damages are necessarily always calculated, but my understanding is that they do not use the same exact formula that would be used in a restitution context. And for that reason, unless it is the same calculus, I don't believe issue preclusion would apply. But admittedly, it's tough to imagine a suit that does not currently exist and imagine how damages might be calculated in that hypothetical suit.
So you just indicated you're not sure how civil damages would work, so of course I'm going to ask you another question about civil practice. And I apologize, I should have asked this of Attorney Chayette, but what civil claims would be brought here?
I would imagine it would just be stolen property, essentially, conversion, if my law school class memory is not evading me. But it would essentially be theft, damages to the car, I believe was one of the elements at the restitution hearing. I can't imagine that there'd be any sort of non-economic damages, but pain and suffering, I suppose. If you wake up and your car is lost, you could argue that. But again, it's hard to imagine what that hypothetical lawsuit is, not having it here. That being said, the court obviously has the discretion to address this case, even if everything is moot, if it escapes review. My argument is essentially that this does not normally escape review, because if restitution is paid, or if probation is lengthy, or if a violation of probation is found after a probation is extended because of the restitution, which I argue here didn't happen, but that could in theory cause it to not escape review, then that wouldn't evade review normally. It's only in the rare circumstance where restitution is ordered, determination of pay is made, and no payments are made, and it is discharged before no payments are made. That would be the rare circumstance in which it evades review, which is the circumstance here. But on all of those other cases, it would not necessarily evade review. That being said, I'm happy to get to the merits of the argument. Now, I think if the court has no further questions on mootness or discretionary review. So as to the continuance, I don't believe it's an abuse of discretion. I think here it was the judge's determination that further enlargement of time would not help the defendant in any significant way, and the defendant's trial counsel conceded that. And then, as I've described, if the court decides to address these issues, the original restitution order was problematic, in part because of the calculation of damages was not necessarily tied to the evidence that was before it. This is not necessarily before the...
When the restitution amount was subsequently knocked down to, I think, $100 a month,
Yes.
did that also lower the overall payment?
No. So I believe the way that it works in the probation context, because your probation might get extended for a very long time for
Right.
other number of reasons, is that your monthly payments are made, and then only until you've paid everything is it discharged. But in theory, if you had a 10, 20-year probation, if it kept getting extended, it would continue to be $100 a month until you've paid what restitution you owed. In this, I think the judge acknowledges that there was no way that restitution in its full amount was going to be paid in the amount that the defendant was likely to be on probation. But in theory, had he kept violating, had he kept having his probation extended, it could have eventually, it would probably be 20 years he'd have to be on probation to eventually pay it off. But that's my understanding how the math works. It doesn't necessarily change the calculation of the victim's losses. And I think that's the important distinction, is that there's two different findings in a restitution context. There is the determination of the victim's losses, which is here incorrect because the math was done incorrectly. And then there's the determination of the defendant's ability to pay. The problem of remedy, if the court does decide to address this, is those are two different calculations. And if the court were to send it back, it would seem that those two calculations would need to be handled separately. Now, it very well could be that because probation has already been discharged, if the court finds that there's no need to recalculate the victim's damages, but that would seem to go counter to the defendant's moot arguments because, again, if the whole reason we're here is because of some sort of issue preclusion thing, then it would need to get sent back for that factual finding as to the victim's damages.
I think the defendant just wants the order vacated, right?
Right. I don't know that that would, even if the order is vacated, it would then need to be remanded for a correction, I would think. I don't believe, obviously.
When it's been discharged?
It's, I think if the issue is whether or not there is an underlying factual finding of victims' losses, I'm not sure why that part of it would get vacated. I understand that the entirety of the restitution order would be, but if the goal is to vacate both the Henry hearing element and the victim's losses, the Henry hearing element I have no disagreement with, but the victim's losses would need to be remanded, I would think. But that being said, again, the Commonwealth has no, this is a very confusing and thorny issue, and if the court decides to handle it by vacating it, the Commonwealth has no objection to that. That is just my interpretation of how this would need to be handled. And all that's, to say, again, overall, this entire case, I believe, is moot. Although there is no case on point that discusses what the difference is between a discharge and a vacate, I don't believe there is a distinction because the factual findings cannot be used in another context, I don't believe. But that being said, I'm happy to answer any questions if the court has them.
Seeing none, well briefed, well argued, the case is submitted. We will take a brief recess.
All rise, please. Court is now in session. Please be seated.
Good morning still. Calling our next case on the list, docket 24P 1040 and docket 24P 1384. Counsel, my understanding is you're splitting time.
Yes, Your Honor.
Okay. We've allotted 20 minutes per side on this case. We understand there are two individual cases with two separate issues. So if you need additional time and we feel that additional time is warranted, we will grant it, but let's start with the 10 minutes allotted.
Yes, Your Honor. Good morning. May it please the court. Charlie Tevnin for the appellant Peter Leiden. Your Honors, my client Peter Leiden is seated in the front row on the left. And this is an unusual case where the two parties, Doyle and Leiden, are both buyers and sellers of property. They are longtime business partners. They agreed in 2019 to do a so-called drop and swap, whereby they would drop this property out of the 394 West Broadway LLC into a tenant in common, and that they would manage 398 and 394 West Broadway as tenants in common for a minimum of 1 year. They made a commitment at that time to do a 1031 exchange in 2020, and they would swap their respective 50% interests.
We are well-versed in the facts of this case. Let me just ask you a preliminary question. Are you planning on handling the summary judgment and your colleague the sanctions, or are you dividing
Yes,
it? Okay.
that is correct.
Very good. So
I'd like to say it's fitting that the hearing today is on April 15th, which is known universally in the U.S. as Tax Day, to illustrate that this was all about a 1031 deferred exchange, a tax-deferred exchange, and that was the essential purpose of these two
Your
transactions.
case number is also 1040. You may or may not have noticed.
I mean,
Your case number is 1040.
and I also noticed that. Thank you, Judge. The co-ownership agreement, at summary judgment, the court resolved multiple questions of disputed material facts in favor of the moving party, Robert Doyle, which was clear error. Those facts included whether either party could perform by the October 14th closing date, whether Mr. Doyle had materially breached the co-ownership agreement first, and last, whether Doyle's past malfeasance, which clearly touched the transaction, required the application of the doctrine of unclean hands by the court to bar the plaintiff from being awarded specific performance. Or to say it another way, Judge or panel members, that the court found at summary judgment that no matter what the finding was in the subsequent trial on the breach of fiduciary duty claims, that no matter what malfeasance had occurred, the court decided in advance before hearing any evidence that no matter what the finding, that the court would not allow the equitable defense of unclean hands. That was error, and we assert that that was also an abuse of discretion. Because in fact, at the end of the trial, a 4-day bench trial, which was all we were afforded, despite all the issues on this case, it was a very limited bench trial on just the breach of fiduciary claims. The outcome was that, in fact, there was a breach of fiduciary duty, and it did touch the transaction because the court found that there was that it changed the payment at the closing by over $72,000 because of a $78,000 distribution that Mr. Doyle had made to himself, but not to his partner, Mr. Leiden. To explain the other summary judgment errors.
Well, just on that, do you dispute the principle that to deny specific performance of a contract under the doctrine of unclean hands, that the alleged inequitable conduct has to directly affect the claim being brought? Do you dispute that principle?
I do not.
Okay, so then you're saying, well, there was that the violation of fiduciary duty that was found at trial changed the amount that was owed later on, but does that really amount to directly affecting the contract claim that's at issue with respect to what happened in 2020?
We assert that it does,
Yeah.
Judge, because Mr. Doyle had a fiduciary duty to come clean about his past malfeasance at the time when they were unwinding this partnership. So in 2020, from August to October, the parties were negotiating what was the final payment figure going to be. And Doyle never mentioned anything about these prior distributions. Now, even though the court found after trial that it was a $78,000 distribution that was made by Doyle to himself and not Leiden, we had asserted that the records that were maintained solely by Mr. Doyle, those financial records, also pointed to a total of $185,000 that he maintained on the record, on the financial records that were distributions to entities that he controlled, that he owned, and not Mr. Leiden. Now, we didn't prevail on that, and we can't change that because the judge found as a fact that just that $78,000 was what was proven. And all we had to prove was, all we were able to use were the business records that Doyle maintained. But what the court should also take into account is that there was a
Well, can I just ask, like, I don't get the connection between what Mr. Doyle, did wrong in the early 2000s and his right that he asserted to specific performance for the deal falling apart in 2020. I mean, that's the problem here. Like,
it wasn't in the early 2000s, Judge. It was shown to be prior
2000
to 2014.
Okay,
And
2012,
so it was
2013,
literally
2014.
5 years, or a little more than 5 years before.
Still, but like I think that's what the Superior Court judge sort of said. Like yes, you have a claim, but it's not related to. It doesn't give you a basis to sort of say there shouldn't be specific performance as to the contract in 2020. And I guess what is the directly affecting aspect of what you alleged Mr. Doyle done wrong 2013, 2014?
Certainly that had my client known about it, he never would have entered into this agreement in the first place. That's the biggest way that it touches the transaction. But I think that the court ought to also take into account the litigation conduct that occurred. So for 18 months, Doyle denied that these records even existed. Now, he had a fiduciary duty to produce the books upon request, and we requested those formally. And he denied that there were even any electronic records at all. And then finally, we had to resort to motion practice and get a motion to compel allowed in order to get access to the electronic records that he had the entire time at his home, but never disclosed. So what I think that the court needed to take into account was the fact that Doyle was going to, through this transaction, forever bury his malfeasance. It was never going to come to light, and it only came to light in the course of this case. And I think that if the litigation had never been filed, my client would never have known about it. My client is of...
Sorry, you used the word malfeasance. I just want to make sure I understand. You're talking about the breach of fiduciary duty, right?
Yes.
Okay.
Yes. And I quoted from the decision, which was after the trial, the judgment after the trial was that the court found, quote, that he ordered Doyle to pay Leiden $72,682.93 as damages for breach of fiduciary duty, because he found that Leiden had withdrawn $78,000 from the partnership, which were not matched by identical distributions to Leiden. That was his exact finding. So, and we assert that Doyle's duty was to disclose those at the time when they were settling their affairs and winding down the partnership. I haven't been able to get to the other points that I would like to.
Go ahead.
All right. With regard to whether or not Doyle could prove that he was able to perform on or by October 14th. There was clearly a dispute about whether or not Leiden's son's email, Attorney John Leiden, who sent us an email in a moment of frustration on October 7th of 2020 to the bank and saying, we don't want to do this with the bank. He didn't say that we don't want to do the transaction at all. We just don't want to do it with East Boston Savings
Says Mr. Leiden does not intend to move forward, right? That's
with East Boston Savings Bank.
right. But
That's what-
he copied Mr. or Doyle's counsel or Doyle himself on that, right?
I believe he counts that he copied that Attorney John Tracy, who actually was representing both parties. He was a longtime attorney.
Looks like both of them. That's also copied to an email address with Mr. Doyle's name in it. I'm looking at Record Appendix Volume 1, page 833.
Well, Judge, I've stated in the brief that there was a question about whether or not either party could have performed despite that. Now, I quoted in the summary judgment opposition from Dan May, the Vice President of East Boston Savings Bank, his deposition where he said that they ignored that email. He said that they just continued to work on doing this.
Well, I mean, I think there are a few things that are clear from the record that's before us, and as you probably know, we have only 4 pages of Mr. May's deposition testimony. We don't have the whole thing. So when I talk about his deposition testimony, I'm talking about only 4 pages. It seems from what we have in the record that East Boston Savings Bank did not completely stop working, but that was because Mr. Doyle was still trying to move forward. So to the extent they were still taking steps, they were doing that at the request of Mr. Doyle. And please correct me if I'm wrong here, but I think the record shows that your client was not engaged with East Boston Savings Bank, either directly or through counsel, after this October 7, 2020 email until the sort of the eve of the drop dead date in the P&S, and drop dead is probably bad language, but you know what I mean.
I disagree, Your Honor.
Okay, please tell me what I'm missing.
If you could look at all of the emails that were exchanged, it's clear that Mr. Leiden's representatives are driving the bus to get this to a conclusion. And they began in August, they worked through September and into October on finalizing this transaction. And it was only when the bank was clearly dragging their feet that October 7th email was sent. But there are other emails, and I turn the court's attention to the emails of October 12th and October 13th, which are at Record Appendix Volume 1, page 829 and 830, between Attorney John Leiden and Dan May at East Boston Savings Bank, where it's clear that Leiden is still attempting to understand what is required by the bank so that they can move forward. Now then...
Well, you say so that they can move forward. I'm looking at page 830, which is an email from your client to Dan May on October 12, 2020, in which your client says, among other things, 3 days after informing you that I no longer wish to pursue this transaction with East Boston Savings Bank and still not having received an explanation of cost, and then he says, you tell me that you have received signed approvals of the loan modifications. What is going on? Why does East Boston Savings Bank need to effectuate this transfer?
And it also, I believe it also says, why is this so hard?
Yes, at the very end.
Yes. So they still want to move forward. They can't get an answer from the bank. Now, I think the backdrop of COVID is important because on October 13th, on the day after, Dan May sends an email explaining that, quote, this is at Record Appendix Volume 1, page 829, He expressly explains the reasons why there's this delay, and it has nothing to do with the October 7th email. He says, quote, "The bank industry is dealing with a multitude of COVID financial impacts, from payment deferments, PPP loan forgiveness processing, and shutdown and delays in our construction portfolio, and layoffs of EBSB bank lending personnel. This little disturbance," referring to COVID, "resonates through every department and delays how quickly paper moves nowadays." That's his explanation.
Well, no, it's part of his explanation, but the very first thing he says in that email, after commenting on the use of pound sand, was, "I have asked bank counsel for an estimate so a decision can be made to proceed. Based upon your direct instructions, we have stopped all work."
But that isn't really true, Judge. So the deposition of Dan May, and you say that it wasn't in the record, but it is, Judge. It's the entire deposition is in, record appendix volume, or at least a substantial portion of it at record
Is it in the
appendix.
summary judgment record?
It's not in the summary judgment
That's the
record.
only
We
thing
can't
that.
consider it.
But I mention it, and I mentioned it in our brief on page 27, footnote 4.
But if it's not in
We
the
can't
record,
consider it.
statement of undisputed fact that was before the judge that made the determination, we're not allowed by law to consider it.
I understand, Judge. My point being that what we did provide in the, as evidence of the disputed fact was a quote from that very same deposition where Mr. May said that despite the October 7th email, the bank continued working. That was enough to create a material, question of material fact. And what the problem with what the Superior Court did is that it then resolved that material fact.
You make that very clear, and your brief is very thorough and comprehensive. You are,
I'd
given
like
you
to just-
16 and a half minutes already, which is beyond the time you're given for an entire case, even though we combined these. So I would give you one more minute to summarize and make your final point.
If I may, Judge. At this point, I'd like to just say what the importance of these disputed material facts that were just highlighted, how the court resolving them against Leiden and in favor of Doyle changes the entire outcome of the case.
We understand, if we agree with you, then summary judgment, if there are disputed material facts that the judge resolved when he's not allowed to, then you prevail. We're very clear on that.
Well, the real question is whether Doyle was ready and willing and able to perform himself on October 14th. On October 13th, he received, later in the day, around 3 p.m., the loan modification offer letters. He did nothing with them for an entire day, and he didn't send them along to Leiden until the next day, which is the date for performance, at 3:35 p.m., with no explanation, just sent the email. How is it that this would have been able to have been accomplished within 85 minutes on the closing date? Our point, Judge, ultimately is that the P&S agreements lapsed and the co-ownership agreement remained, and the October 15th email from Attorney John Leiden reinforces that Mr. Leiden intended to continue to be bound by that co-ownership agreement.
Understood.
But the other problem at...
We're going to have to leave it there. We've given you more time than had this case been argued singularly, so we're going to have to leave it at that.
Understood. Thank you, Your Honor.
You're welcome. Hang on one second. Okay, why don't we do it this way? Let's have the appellee argue. Are you going to do both arguments?
No, Your Honor.
Okay, you're splitting your time as well? So put you on the clock for 10 minutes, and we'll hear from the appellee on just the summary judgment issue.
I think I was given 15, Your Honor. I don't know that I'll need it, but
And you're doing 5? Yes. Very good. The clock has been reset. Thank you. Go ahead.
thank you, members of the panel. My name is Nisha Koshi, and I represent the appellee, Mr. Doyle. Contrary to my brother's contention that this is a very confusing and convoluted case. I actually think it's very simple. And I think there's a reason why there aren't cases here every day with parties seeking to seek specific performance with facts like these, because the facts are very clear and undisputed that on October 7th, 2 days after the purchase and sale was executed, Mr. Leiden's very clear words that have no other meaning other than "I'm not proceeding forward with this deal" was a clear and unequivocal repudiation of his obligation to tender a deed to the property to our client.
So hold on one sec. Let me ask you about that. Is it necessary for him to have gone through with the deal? Was it necessary for him to have worked with East Boston Savings Bank?
Yes, both the co-ownership agreement and the purchase and sale agreements, Your Honor, imposed on the parties an obligation to cooperate with each other to effectuate the purpose of the agreements. So with respect to the co-ownership agreement, it was very clear that the parties had to cooperate in terms of transferring their respective ownership interests in the two properties, maintaining that tenants in common ownership during the holding period, and then ultimately to the purchase and sale agreement to deliver title to the property on the closing date of October 14th.
And so you've told me a lot about the parties' obligations. Where does East Boston Savings Bank come into that?
So Mr. Doyle continued to work with East Boston Savings Bank after the October 7th repudiation in an effort to try and get this matter to close, because he understood that he could not unilaterally terminate the agreement and walk away without consequence. So it was his intention to appear at the effectuate the closing, but the law says that once Mr. Leiden repudiated, Mr. Doyle didn't have to go through the ministerial efforts of actually showing up for a closing, but it is undisputed that Mr. Doyle did take efforts after the October 7th email to continue to work with East Boston Savings Bank to get this
just
closed.
indulge me for a moment. Your brother has argued that Mr. Leiden didn't say, "I'm not doing the swap." He said, "I'm not working with that bank anymore." People refinance all the time. My understanding, which is rudimentary at best, is that you don't need to go seek permission from your current bank to refinance with another bank. Would it have been possible, and this is a lot of hypotheticals, but in a world in which Mr. Doyle and Mr. Leiden were still working harmoniously, for Mr. Doyle to say, "Okay, you're sick of those people, I get it, we'll just refi with another bank and then we'll go forward with the swap"?
Well, the mortgages on both of the properties were held by Eastern Bank, and so in order to have Mr. Doyle be fully liable for the mortgage on the 394 property, there needed to be a loan modification to make him solely liable, as they had both been liable on that mortgage, and same with the 398 property, they were both liable. So there had to be a loan modification process. That process stopped by virtue of the clear emails from, the clear October 7th email from Mr. Leiden's attorney. And regardless of that, his action made it impossible for Mr. Doyle, for either party, to deliver clear title at the closing. And as a result of that, they're claiming that that made it impossible. That was a prior breach of the agreement. And the reality is that Mr. Leiden had time and opportunity to retract his repudiation. He chose not to. The bank emailed on the 8th and the 10th, we can simplify the modification process by having you sign these loan modification documents. Do you want us to continue? There was no response to the October 8th email, no response to the October 10th email. Then there was a final response on October 12th, not rescinding that repudiation, but, and not indicating that he intended to close on the 14th as required by the purchase and sale agreement. They claimed that Mr. Doyle didn't have the, was not ready, willing, and able, because the law provides, as quoted in our briefs, that once Mr. Leiden repudiated, Mr. Doyle didn't have an obligation to proceed with the closing. However, where their obligations were concurrent, Mr. Doyle had an obligation to establish that he was ready, willing, and able. And the case law shows that if they can establish that they had funds sufficient to close, which was the boot payment of $215,000, then that is sufficient to establish, and that is undisputed by Mr. Leiden, that Mr. Doyle had the cash ready to close. So then they go, as I've already explained, to the issue that he couldn't deliver clear title. Again, he can't benefit from ceasing us to deliver clear title by his conduct. If his repudiation resulted as a matter of law in the inability to close, the parties had an obligation to cooperate. They had an obligation to work together to try and clear those title issues. And then in the purchase and sale, Mr. Doyle had the opportunity to accept whatever title was given to him. But he was never presented with that opportunity because Mr. Leiden had unilaterally essentially walked away from the deal. You can't just terminate a deal and walk away and expect that you're not going to suffer from the consequences. In this case, the consequence was that the bank might not have been able to deliver the loan modification by October 14th. But at the end of the day, that's not relevant to the issue as a matter of law, because there is no other facts submitted to support what the delay would have been, other than, and as quoted in Mr. May's emails, he specifically says, we are not proceeding forward based on your directive, regardless of the COVID issues or otherwise. And just
Are you also addressing the counterclaim on the breach of fiduciary duty claim?
Yes, so, and the court, Superior Court obviously found that Mr. Doyle had breached his fiduciary duty by failing to account for certain funds that had been taken from the LLC that hadn't been adequately shown on the other end for Mr. Leiden.
Hang on a second. All set. Go ahead.
And Mr. Doyle does not dispute that. They were remote in time. They were far in advance of the timing of the negotiation of the co-ownership agreement and the purchase and sale agreements. They were not only remote in time, they really had nothing to do with what the co-ownership agreement was formed for, which was the drop and swap. And ultimately, on the breach of fiduciary claim, the judge ordered Mr. Doyle to pay the difference based on the accounting, based on what was discovered at trial and the accounting that the judge essentially conducted by reviewing those records.
So what about your brother's argument that, well, had he known about the breach of fiduciary duty, he would never entered into the swap transaction to begin with?
It's very difficult. I mean, that's an entirely speculative argument. There is no factual basis for that claim. There's no factual basis for that argument. Not only that,
Why
Mr.
is it
Leiden,
not? Wait. Why is that not a reasonable inference to draw?
well, because the timing of the whole purpose of the drop and swap was because the parties wanted to disentangle themselves. That wouldn't have changed if the amount of the boot had changed. They still wanted to disentangle themselves so that ultimately Mr. Doyle, they no longer wanted this partnership to own these properties. So they decided, let's separate from each other, and you will, Mr. Doyle, own 394, and you, Mr. Leiden, will own 398. So that was what the purpose of the co-ownership agreement was. The boot was just an accounting error that, by virtue of not keeping sufficient ledgers and accounting books from 16 years prior, 10 years prior, got lost in the shuffle. I think after a thorough investigation by the Superior Court, it was found that none of that conduct was intentional. It was all negligent, and Mr. Leiden was made whole by virtue of the damages award granted to Mr. Leiden. So once the sale is effectuated by specific performance, as ordered by the Superior Court, Mr. Leiden will get the difference between those accounting calculations.
It's not obviously part of the record before us and will play no role in our decision. What is the current status of the ownership of the two buildings? Oh, it's all right. I'll just ask you when you're up. Thank you.
So the other issue relates to my brother's argument regarding unclean hands. And the law is clear that in order for an unclean hands defense to negate an award of specific performance, it would have to be, again, touching the transaction and also more than just a negligent malfeasance. It would have to be an intentional malfeasance, and we cite to quite a number of cases that cite to that proposition. So you can't.
Why is that not a question of fact for a jury, or a fact? Why is that not a question of fact here?
Whether the breach of fiduciary, whether there was unclean hands?
Unclean hands.
The unclean hands, the judge made a determination based on, the judge did a fact-finding, had a fact-finding endeavor because there was no
Almost like in
right
the form,
to a jury
almost in the
trial.
form of like a proffer in some sense, but go ahead.
The judge made a detailed factual inquiry into the accounting. So all of the facts came forward during that hearing, during that trial, as to where the monies came from, where they should have gone, and the judge in his discretion determined that this was not intentional malfeasance.
But that came after the summary judgment ruling, right?
Correct.
So
yes.
I guess the question is, at the time of the summary judgment ruling, how do we know this wasn't a genuine issue of fact? And it seems there you're resting primarily on it not, on the fact that it didn't, the timing sort of removed it from the swap transaction, as opposed to whether there was intentional versus negligent wrongdoing. Is that correct? Because you can't really establish that based on just the summary judgment record.
Well, because the breach of fiduciary duty came after, and that originally it was an affirmative defense, and the judge said this should be pled as an actual counterclaim. The unclean hands was an affirmative defense, and they're analyzed differently from each other. Whereas the breach of fiduciary duty can be established on negligence, and that's what the judge found. Whereas the unclean hands, as an affirmative defense and is in the discretion of the judge, shall be based on a higher standard of intentional bad faith misconduct. And, we don't dispute, Your Honor, that they owed each other fiduciary duties. Mr. Leiden has been made whole by the judge's decision granting him a judgment in that event. And the final issue, Your Honor, that I would like to address is that our request for attorney's fees. After the summary judgment decision was entered by the Superior Court, Mr. Leiden took at least 5 more bites at the apple to get the decision overturned, changed, remanded, all of which were summarily denied, including by a single justice of this court. None of the arguments in any of those pleadings has changed. They've all been exactly the same, and the reasons for denial have been the same, and as a result,
Your time is up, but you can finish your thought. Go ahead.
So it is in this court's discretion, under the statute, Chapter 211A, Section 15, whether to grant attorney's fees. We'd ask that in light of the significant delay that has been caused by the motion practice in this case, this is now, we're going on 6 years since the transaction should have occurred, and at significant cost and delay to Mr. Doyle, we'd ask in the court's discretion to award attorney's fees.
There's no fee shifting provision in the contracts, right?
No, there isn't. It's
Okay,
by
thank you.
statute, Your Honor, and the appellate court rules.
Okay, thank you very much. And Attorney Kiernan?
Good morning, members of the court. My name is Patrick Kiernan. I represent the appellant, Peter Leiden, and this is for the would be for the contempt, which is, I believe, a 1384, perhaps 94. But and so so what happened was, after the judgment was issued, Mr. Leiden did seek a stay because equitable orders are not automatically stayed by notice of appeal.
Denied by the Superior Court. It was denied by the single justice.
And denied by this court's single justice, yes, Your Honor. And as such, a trial, pursuant to Rule 65.3, a show cause hearing was held, and then a trial on contempt was held. The judge issued a decision finding Mr. Leiden in contempt. However, we object to that decision on the grounds that Mr. Leiden did not violate a clear and unequivocal command. And just to kind of set the stage on contempt in Massachusetts, you know, the review is abuse of discretion, but all
Clear
findings of law are de novo.
and convincing evidence, and
Yes,
we're
clear and
aware of
convincing
Birchall and Cooper v. Keto, et
Yes.
cetera.
But perhaps most importantly, not every violation of a clear error will rise to the level of contempt. And our case law says that gives the requirement teeth. And also, the defendant has to have the ability to comply.
Counsel, you really may want to turn that phone off. It's twice.
And so,
Go ahead.
So the gravamen of this stems from the fact that the final judgment, as ordered, incorporated by reference the purchase and sale agreements, both of them, and the co-ownership agreement. And here we run, the evidence of the contempt trial showed we run into the same problem where—
I want to pause you for a minute, because in your brief, you do say, you use that word incorporated, presumably quite deliberately, when you're talking about the relationship between the judgment and the underlying contracts. I noticed that the briefing and argument in the trial court was less confident about incorporation and said something like kind of incorporate or quasi-incorporate. It is true, obviously, that the judgment refers to those agreements. Is it necessary for your argument to succeed that we decide that they were actually incorporated by reference?
Perhaps, but I would say that the judgment says Mr. Leiden is to perform the transaction as defined in the agreements. So the command was, you have to do what's in the agreements. And that set the stage for what Mr. Leiden was supposed to do. And as—
So let me ask you a question about that. So, I mean, as I read Justice Salinger's order, it in essence was, look, do what the co-ownership agreement says you have to do. Is that a fair summary?
yes, he wanted the transaction to close as agreed to.
And your position is you really can't do it as agreed to. So how far are you going to take that? For example, one of the provisions, I think, was that time is of the essence, right?
Yes.
By the time specific performance was ordered, time is of the essence has long passed. So would you be making the argument that because you can't satisfy time is of the essence, that's not, you can't comply with that order?
No, Your Honor, I wouldn't make that argument.
Okay, so you're not going that far.
The time is of the essence clause was in 2020, so no, I mean, I think
Okay.
the contempt order went down last year, so I'm not going to make that argument. But in terms of the structural mechanics of the deal, again, the requirement that both parties had to give clean title remained. I mean, that was essential to the transaction. And the evidence adduced at trial, Mr. Doyle testified that, yeah, I contacted the bank, but I didn't fix it. So by the trial judge ordering them to comply like right away, $1,000 a day, the court received evidence that we can't do that right away. And if I may look at my papers, Your Honor. What the court says here. And, you know, the trial judge acknowledged that, and I quote on page 22 of our brief, many in its record appendix.
Because during the hearing, she said, yeah, you guys got to coordinate. A lot of stuff has to be done.
Yeah, a lot of stuff has to be done. A lot of things have to come together. Counsel for Mr. Doyle agreed that we can't do this right away. So I guess the gravamen of the argument here is that the contempt order went beyond what was necessary to coerce. And in effect, by saying it's $1,000 a day right now, you're punishing Mr. Leiden. It goes beyond that because having received evidence that we can't do this today, and then saying, well, $1,000 a day starts today, Mr. Leiden was forced to transfer the deed without involving the bank. And if I may, Your Honor, there's, and this somewhat relates to the last one, but I'm not going to go into any argument on that. But one of the reasons this had to happen was there was the due on sale clause of the mortgage. The bank was clear on that we may enforce that. These loans could be called immediately. So by the trial judge ordering them to transfer this right away, Mr. Leiden just had to deliver a deed and take the risk that, for both parties, that the bank might, in fact, call the loan. And that's not what the agreements say. The order then affects a third party, the bank, who obviously has its own procedures on how they would like this done. And it goes far beyond what was necessary to coerce Mr. Leiden to do this. And thus it's an abuse of discretion because it goes far beyond the reasonable alternatives available. And something reasonable, which I think, you know, based on the colloquy with the court and everything that was happening was, okay, contact the bank, see if you can get this done in 2 weeks, something to that effect. When can the bank do this? If Mr. Leiden doesn't do it when the bank is ready, yeah, then we can have $1,000 a day. But to say that Mr. Leiden has to do this now eviscerates the order and the judgment to comply by executing the transaction as agreed to.
So you don't dispute that specific performance was an appropriate remedy? I mean, I know you, in the underlying summary judgment, et cetera, you dispute that, Mr. Tevenan's argument, but you don't dispute that specific performance was an appropriate remedy, right? You're just disputing the timing.
Yes, so if I understand the court's question, yes, we do dispute it in the primary appeal.
Right.
But yes, here, yes, we have to comply with judgments as written unless this court were to change something about it. It is a judgment. So yes, specific performance would be ordered, but they're both buyers and sellers in this transaction, and they both had to coordinate this somehow. And in fact, Mr. Doyle testified, one of the reasons I didn't do this was because I needed a closing date. The bank wouldn't let me do this myself because I needed a closing date. Well, he never informed Mr. Leiden. I mean, we found out about this during his testimony at the contempt trial for the first time. He never informed us that we needed a closing date. I mean, that necessarily implies something to agree to. Even if not something to agree to, he had at least find a day and say, hey, I want to do it this day. The bank's ready this day. And by the time we got to a contempt trial, that had not been done. So Mr. Doyle was, again, not in a position to give clean title, which the agreement requires, and therefore the contempt was premature here.
So I want to get back to the question about what was actually ordered, and obviously both orders, both judgments, the contempt judgment and the underlying judgment are in the record appendix in volume 2, and the contempt judgment requires your client to pay $1,000 per day until he has fully complied with the judgment. The underlying judgment says your client is hereby ordered to fully perform and close the transaction required in the parties' COA and their P&Ss. My question for you is, from where do you take the interpretation that the contempt sanction order of complying with the judgment requires immediate closing as opposed to beginning to take steps to fully perform the transaction?
Because the decision in order I'm looking at this thing. It's the findings of facts. I apologize, Your Honor, if I may.
That's okay. What are you looking for? Maybe I
Yeah, I
can
was going
help.
to ask the same.
So, yes, so it's page, it would be, on our brief, it would be in the appendix, page A078. So her exact order was that the order was issued on the 21st.
This is Record Appendix 2, what, we're 1456?
62, I have 1462.
1460,
Yes.
oh, the final order, 1462, thank you.
To be page 7, the final page of the final order.
Got it.
Where she gives her, her order. So the order is issued, as you can see, it's dated on the 21st. On the 22nd, beginning on October 22nd, Peter Leiden shall pay Robert Doyle $1,000 a day until he has complied with the judgment.
It says fully complied with the judgment.
Until he has fully complied with the judgment.
And my question for you is, what makes you conclude that fully complied with the judgment means closing and not fully perform and close the transaction, which is what Justice Salinger's judgment says? In other words, it seems to me that there is a possibility that Justice Squires-Lee's order could mean you got to get the ball rolling, like now, with an eye to closing, and that's complying with Justice Salinger's order. Do you think that's wrong? You can say, yes, I'm wrong sometimes.
I respectfully do disagree with that.
Okay.
I think, we read the order as beginning today, you've got to pay $1,000 a day until this is done, until you have fully complied with the judgment. So at that point, Mr. Leiden thought, if I don't do this today, if I don't do this by COB today, I'm on the hook for $1,000 already. If I wait for the bank and they take 2 weeks, that's $14,000 potentially.
And if they take more than a month, he could go to jail.
Exactly. So it was that fear, I realize I'm over time, Your Honor. But
Thank you. We're going to give you additional time. Go ahead.
So yes, it was the fear of incarceration plus the date saying, you've got to pay $1,000 a day that forced him to just turn over the deed without contacting the bank, without him, I understand that he's an alleged contender in this case, but if they have to perform the transaction as agreed to, Mr. Leiden, part of that was he was able to receive his half of 398 West Broadway, and with clean title. And again, we had, other than the evidence we received at the contempt trial that Mr. Doyle had not yet effectuated that, we had no update at that point that had been done either. So in other words, the contempt order went too far in affecting the rights of the bank, because we just had to convey title, and that could have triggered the due on sale clause. And as I stated before, the bank was rather adamant. And there was an email back from 2020, it's Record Appendix, Volume 1, 835, where they say, no, actually, we do care about this. That will be a title transfer event. That's a sale. We can call the loan. So this entire case, we've had that hanging over our heads. So the order went beyond and affecting the rights of the bank vicariously.
Have 398 and 394 been swapped, for lack of a better term?
Yes, so that did occur on the day this order came down to avoid the $1,000 a day. And, we submit to the court that because we had a contempt order in place, we did this under duress.
And your brief makes that clear.
So, yes, they have been transferred at this point.
Thank you very much.
Thank you, Your Honor.
If it pleases the court, Attorney Michael Brangman on behalf of appellee Robert Doyle. May I take a moment to address questions that were asked on the summary judgment issue before I speak to the contempt?
It's your 5 minutes. Go ahead.
Justice Toone, I believe, asked about the argument that Peter Leiden never would have done this deal if he had known that sometime prior to 2014, there was a capital account disparity in the partner's LLC account that suggested withdrawals that favored Robert Doyle. And the breaches of fiduciary duty that were found were the result of 16 years worth of business records, some of which were contained on a computer that was found in Mr. Doyle's shed and produced immediately, and that was what gave rise to the complaints regarding motion to compel and late production of documents. These were very old dated business records, and Mr. Doyle at trial was put in a position as the sole uncompensated LLC manager to explain every single transaction that had occurred in this LLC during the 16 years of its existence. The breaches of fiduciary duty that were found, I would submit to this court, and I think it's reflected in the decision, represent an inability by Mr. Doyle to do that based on very scant business records that remained and existed. And that responsibility was on him as the LLC manager to keep those records, and I think that he was, that was what resulted in these breaches of fiduciary duty. Attorney Koshy pointed out that there was never an express finding of intentional malfeasance, and Justice Neyman, you asked, isn't that a question of fact? It may be, but I don't think that's the critical point here. The critical point is that all of the allegations and indeed the later findings of breach of fiduciary duty had to do with conduct that occurred at a minimum before 2014, and this transaction was contemplated in 2019. Now, Mr. Leiden now says, I never would have done the deal had I known that there was this capital account disparity. That same argument could be made with respect to anything in the context of unclean hands. You could say that I never would have done this deal with you if I'd known when we were in middle school you deflated the tires to my bike. I didn't know that was you. The two things are completely unrelated. They don't tie together at all, and I think the case law on this is very clear. There are instances, and there are other cases cited in our brief, where the two parties have prior unrelated transactions, and there is some alleged malfeasance, or in fact there is malfeasance, but because the two transactions are completely unrelated, that the unclean hands doctrine doesn't apply. And that is not a question of fact for the jury. That is a question of law that was appropriately decided by Judge Salinger. So that's my long-winded answer to that question.
That's helpful. Let's talk about contempt. How, within 1 day of Judge Squire's order, could they have possibly complied with the final judgment?
Well, I think it's evidenced by the fact that they, despite arguing, and this wasn't just at the contempt trial, but in the 3 months from the original order to the contempt trial, Mr. Leiden did absolutely nothing to attempt to comply. That alone defeats his impossibility argument because it requires diligent effort to comply.
Right, but it says fully perform and close the transaction required in the co-ownership agreements and the P&S agreements. It seems to me that you're giving this a more narrow reading and saying, look, basically you had to exchange deeds and that was good enough. That does not comply with all of the terms, all of the material terms of the co-ownership agreement and the P&S agreements.
And, Your Honor, could arguably Robert Doyle 2 days later have filed a further contempt action because all of the terms weren't filed? I don't know if that was the intent of Judge Squires Lee's order. What I do know is that it can't be argued that this order, the original order, was ambiguous, where immediately upon being faced with $1,000 per day sanctions, Mr. Leiden knew exactly what he needed to do. He needed to write a deed, and my client wrote a check, and he wrote a deed, and that's what was contemplated by the order. So
couldn't she have fashioned the remedy as such? Get him the deed within the next few days and complete the transaction within the meaning of as Justice Salinger's final judgment dictates by X date. Then we wouldn't have this potential issue.
Well, could any order, I think most orders could be written better in hindsight when they're dissected with a microscope, but I think the inquiry on contempt is whether the contemnor was on notice of the conduct of which he needed to comply. That's not a perfect recitation of the law, but that's essentially what it says is, do you have notice of what you need to do? And Mr. Leiden very clearly did, because as soon as he was
Your
faced
time
with
is up, but
sanctions,
you can complete your answer and we'll have some follow-up, so go ahead.
Thank you. I wasn't even paying attention to the light, but as soon as he was actually faced with real sanctions, he did what he needed to do, which was convey a deed. My client knew what he needed to do, which was the brunt of this transaction was conveyance of deeds, 50-50 swap of interests, and payment of the closing adjustment. Everything else was secondary to that, and it's unquestionable that Mr. Leiden knew that. And
doesn't Cooper v. Keto teach us that when we're looking at contempt, you really have to dot your I's and cross your T's?
Well, I think Cooper v. Keto really stands for the principle that in that case, the order in question specifically said agreed upon college expenses, and there was no expressed agreement.
There was no express agreement, but the mother said to the father, our kid wants to go to Bard College. How about it? He doesn't respond. She says, hey, he's applying to Bard. The husband has his wife, who is the son's Chinese teacher, teaches him Chinese, write a letter of recommendation to Bard College because of the Chinese language department there. I mean, there is evidence from which, in that case, it was almost impossible not to conclude that he at least tacitly agreed. And what we held in that case is not good enough. It needs to be very clear.
Well, I think.
And I'm concerned, just in this case, just to show my cards, I'm concerned about a potential ambiguity in this case or potential lack of clarity similar to Cooper v. Keto. So how do you address that?
So in Cooper v. Keto, you're correct that the husband in that case implicitly or by silence, really, I think the case, the court was looking at it under contract principles of acceptance by silence. The father remained silent under circumstances that any reasonable person would have objected if they intended to. And he really was using that to his advantage so he could say, aha, I never expressly agreed. But the court said it doesn't matter because this order says by agreement. I don't remember the exact language, but there was agreement necessary, and there was never even an attempt to agree. And I think that's what the appellant is trying to make an analogy to this case, is to say there was never an attempt to agree. But this case is distinguishable from Cooper in that respect, in that Mr. Doyle testified at the contempt hearing, and this was not contradicted in any way, that after the order came out, he reached out to Mr. Leiden through counsel, and he asked to close on the transaction, and that was refused. And then Mr. Leiden went through with his appellant practice, the last-minute motion practice, et cetera. But
So what you're saying is it was you're almost applying a rule of reason, and you're giving us all the background, kind of like in Cooper v. Keto, where it's a reasonable inference to draw.
Well, I will add this, is that there's been a lot of pointing, and it's funny that this contempt issue seems to be a microcosm of the larger case, because Mr. Leiden is saying, Mr. Doyle didn't do this, Mr. Doyle should have done that. Mr. Doyle wasn't ordered to do anything. Mr. Leiden was, and he did nothing. That's beyond dispute. There was no evidence at the contempt trial that Mr. Leiden even tried in any way to comply with the court's order. So I think that distinguishes it from Cooper v. Keto, and the fact that my client, to the extent the demand was even necessary, which I don't think that it was, but he made a demand, comply with this order. Mr. Leiden simply refused, went through appellate practice, and 3 months later we had a contempt trial without any effort to comply.
So you're past your time. Let me see if anyone has any further questions. No. Okay. Thank you for your arguments. We really appreciate the extensive briefing, the excellent argument. Your clients have been well represented. The case is submitted. I should say the cases are submitted. Thank you both. Calling our final case, docket 25P358, State Police Association of Massachusetts versus Department of State Police. Whenever you're ready, counsel.
Good afternoon. May it please the court. My name is Leah Baralt, and I am here to represent the State Police Association. As I'm sure you've seen in the papers, this case involves the termination of 13 state troopers. They underwent an internal trial board process, were terminated. The union then filed a grievance under the collective bargaining agreement that it has with the State Police Department, processed through the steps, filed for arbitration. When we arrived at arbitration, the arbitrator declined to hear the merits of the case and instead dismissed the grievance, finding that it was substantively arbitrable. We appealed. Now we're here today. The issue that I want to start with, which I think has been the biggest stumbling block in both the arbitrator's decision and the Superior Court decision, is the finding that was made regarding the collective bargaining agreement between the union and the state police department having no language permitting grievance and arbitration over discipline. You know, the Mass State Police Department and the Mass State Police Association are public employees, employer public organization for purposes of the Mass General Collective Bargaining Laws 150E. They have a contract that they developed according to that law. In Article 22 of that contract, which is on Record Appendix 109.
That's the grievance provision.
The grievance provision, yes. And it allows for disputes over application and interpretation of contractual provisions. The contractual provision at issue here comes in Article 2 of that same contract.
So does your argument fundamentally that someone has to determine what constitutes just cause, that is a term of the agreement, and therefore reading Articles 22 and 2 together, that makes it arbitrable? Am I stating your argument correctly, or am I missing something?
No, I think that is very close to my argument, meaning that I think if in the instances when the state police and the colonel exercise their control with a just cause, then, you know, whatever result that comes out of that is untouchable. If there's a question in a particular application of that language to a fact set that the colonel or the state police acted without just cause, that's an issue that can be arbitrated and go before a fact finder. And if it's determined that there was not just cause, then that complete discretion and control is lost.
Well, why wasn't that carved out in, I think, is it 150D7?
Meaning the contract or?
150E, sorry.
7D.
150E, Section 7D.
Yes. Are you talking about the Colonel Statute
Yes.
22C, Section 13? Well, I guess I would start out by saying that that is a statute or a section under 150E. It lists the statutes that a contract can supersede. If it isn't listed there, I think the analysis by the court and the state is off with respect to then what happens.
Why? Why?
A contract can cover a topic that is covered under a statute that is not listed. Those two things, however, cannot material conflict. So it's not a matter of if the statute is listed, your contract can't cover any part of it. It's a matter of your contract can still cover something that may be covered by that statute. It just cannot materially conflict. I'm sorry.
No, go ahead.
So I think, you know, you raise that issue, which is important because here there is no material conflict. Under 22C, Section 13, it governs the internal trial board process for a state trooper individual. It then states that a person aggrieved by a trial board may appeal to the Civil Service Commission through sections 41 to 43 of the law. It's use of the word optional, may. With respect to the contract, an employee may also file a grievance with their union. It's an optional thing. So there's no material conflict. Either way, an employee can choose to have their dispute heard at a particular forum. And I think what's really important about 22C, Section 13, there's been this jump to conclude that is this exclusive route of discipline appeal for troopers. But nothing in that law says that. And in fact, I would point you out.
Already says it's the right route. It doesn't say it's the exclusive route, is your argument, right?
And I'd also point a very important part of Doherty that I noticed this morning that I wanted to bring to the court's attention. It's on page 495. In the Doherty case, what the court was looking at is making sure that troopers were getting the same rights that any other public employee of an employer that adopts civil service law gets, meaning, and they use the words exclusively, they want the commission of the jurisdiction to be the same for the troopers as it is for any individual employee that is employed by an employer that adopts civil service law. So they were looking at the types of discipline that other employees can file in that forum. In that case, the state police trooper was trying to, I think, grieve loss of accrual pay. And under the civil service statute, it expressly states what things can be aggrieved, and that is not one of them. The court said, look, you don't get any different rights than any other public employee. The commission has the same jurisdiction. And why that's important is as follows. Under 150E, Section 8, which is referenced in my record appendix the addendum on 76, this is another piece that I think gets overlooked by the court. The Civil Service Commission is expressly divested of jurisdiction of any appeal filed pursuant to 4143 when it involves an employee that's organized, has a contract, and can otherwise grieve their discipline. The state police, under their own statute, 22C, Section 13, the legislature took jurisdiction of that employee's appeal route and gave it to the commission. If an employee appeals at the commission, the state police has no control and no jurisdiction over where that appeal goes, and as a matter of law, the commission loses that appeal if an employee elects to use arbitration. And this is important because I think the concept is you can't have two bites of the apple. You should only have your decision heard in one place. So in that way, again, with respect to 22C, Section 13, an employee who, with their union, decides to file a grievance under Article 22 and say that Article 2 is not applied correctly, if they decide that they're going to go to arbitration, as a matter of law, even if they had filed a civil service appeal, that would have been divested.
Are you aware of any case where that's ever occurred?
There are likely multiple civil service reporter decisions where that has occurred. I mean, it has come up frequently in my practice at the commission, so the way the commission deals with...
Someone has appealed the colonel's discipline resulting in termination or suspension and has appealed it to an arbitrator, was found to be arbitrable?
I would say not in the case of a trooper, because that's the issue before here, because the state police has taken a position for time memorial that troopers cannot avail themselves of a grievance to appeal their discipline. So
to your knowledge, it's never been done, never been allowed, but you're challenging that?
What I am challenging is that under the civil service law, any employee who is the employer of somebody covered by that law, if they file an appeal there and they also file a grievance under their contract, the commission is divested of jurisdiction of that discipline, electing arbitration as the exclusive route. What I am saying, and what Doherty makes very clear, is when the legislature put that reference to being able to appeal, because maybe I should have backed up, the state police are not governed by Chapter 31. They're not a civil service employer. The legislature wanted to give employees a neutral forum for them as a person to appeal. So they inserted into 22C 41 through 43 of 31 to give them a route to appeal. That's what Doherty was talking about. So Doherty's like, okay, you're not really civil service employees, so we want to make sure that you're getting the same rights that any other employee files here, that you get treated the same. So with respect to that aspect, once a trooper files an appeal at civil service, the state no longer has jurisdiction over any decision they make or any jurisdiction that the commission then has over that appeal. And there's nothing in that contract that prevents that employee from filing a grievance. And I think the reason that it's, pardon me, a big deal for the union is that, in Massachusetts, of the 30 to 40% of the communities that adopt civil service law, employees get this same choice, police and firefighters. If you're in a civil service town, you're disciplined. You can file an appeal at civil service, hire your own attorney, and do things your way. Or you can file a grievance under your contract and with the help of your union, make an argument that the discipline was unfair. I think it's very important to unions to be able to have the right to challenge a discipline when one of their members has been treated unfair. They have the right to not allow precedent to occur.
So I'm going to ask you a series of questions, and I'm going to try to keep them straight in my head, and then we'll try to remember what they were. You've said that the employees have a right to file a grievance. Mm-hmm. Question one, where is that in the CBA?
Article 22.
Okay, and the Article 22, in your view, gives a uniformed trooper the right, I can't do two things at once, there we go, to file a grievance related to discipline up to and including being terminated, because that is, tell me where I'm going wrong, because that is, quote, a dispute concerning the application or interpretation of the terms of the CBA?
Yes, and the term of the CBA in dispute is Article 2, that states that the colonel has the right to discipline, provided that it's with just cause. If you feel that it has not been done with just cause, then that gives you a right to file a grievance stating that the application of that Article 2 language was improper as to a particular situation.
And you mentioned earlier that this is a very important right for the union members, which seems to go without saying, assuming that it is a right that they have. Is there anywhere else in the collective bargaining agreement that expressly talks about the arbitrability of this kind of decision, or are you grounding it only in Articles 2 and 22?
There are sections in the contract. So every application or interpretation of an article would be subject to Article 22. There are provisions in the contract where portions of articles are subject to arbitration and some portions may be not.
And I can't figure out how to read, this contract is, you know, there's a saying like a camel is a horse made by a committee. There are portions of the contract where it specifically carves things out of arbitrability, and there are other portions where it explicitly puts things into arbitrability. So for me, as one person reading the contract as a whole, it's hard to say what the default is. Is the default that it's arbitrable or not arbitrable? I think the law answers that question to a large extent, right? Which is both Massachusetts and federal law say, if arbitration's in the room, it's the default.
Correct.
Absent whatever the language is about forceful exclusion.
Correct.
Do you have a better or additional answer?
No, I think, and I think probably what you're pointing to is I can really only think of maybe two provisions in the whole contract that have some language that relate back to discipline or the contract. I think that's the fitness provision and the drug provision, 36 and 37. And it's more of just saying, you know, because the default is any article of the contract that you believe has been applied incorrectly or interpreted incorrectly, you can grieve. Those provisions have some nuances of aspects of it that you could grieve or what the procedure would be. The article in question in Article 2, I think, is quite clear, and I feel like the part that was missed by the arbitrator in the court, they sort of stop at the colonel has complete control and discretion over discipline, including termination, and they end there. And I would agree, if it said that, then, you know, there might be an issue arbitrating discipline. But they add the clause just cause, which is a fundamental labor provision, and which is a, you know, big, vast sea of principles that have to be looked at: progressive discipline, mitigating circumstances. And so by putting that in there, basically, if I feel that that article as applied to a situation was the colonel not acting with cause, I can challenge it. If I'm wrong and an arbitrator says he was acting with cause, I think there would be limits on what that arbitrator could do, because then the colonel would be found to have control and discretion. But if it lacked cause, then the arbitrator could do something about that as well.
Well, we'll hear from the department soon,
Yep.
but I assume that their argument is, one, in Article 2, you have this very strident language of the employer having right to exercise complete control and discretion over discipline issues. And then they would say just cause in this context means as determined by the trial board, the colonel, and ultimately the Civil Service Commission. Particularly when you look at other provisions like Article 36, where they sort of exclude disciplinary issues from what can be grieved. Why isn't that a reasonable reading of these provisions in context?
I'm sorry, what was the?
Why isn't a reasonable reading of what just cause means is just cause as provided under the protections of Chapter 22C, Section 13?
Because the just cause standard that is applied at the Civil Service Commission, which is the mechanism that the legislature attached to 22C 13, is fundamentally different than the just cause standard under a collective bargaining agreement. The just cause standard at civil service is a lot more employer-friendly. It's whether or not the employer acted reasonably. In a arbitration context, the arbitrator looks at principles to see if actually what occurred was right or wrong. It's a more favorable standard. And I think the important issue for the union...
Just cause is not, I'm sorry to interrupt, but just cause is not defined in the CBA.
No, it is defined in books and books of labor law. It's a standard that has, been applied over like 50 years. And you look at vast elements of were people warned of things, progressive discipline, are people being treated differently? So it's a in the labor world, that just cause, word alone comes with a treatise of information. And I do just want to make sure that what is understood is that...
Your time is up, but go ahead and finish your thought.
This is not like just we're upset about one case. The arbitration award that came out basically says the union can never file a grievance and challenge any employee's discipline. And I cannot believe that the legislature, when they inserted Section 41 and 43 into 22C to give a person an individual right to appeal to the commission, meant to fully take away from unions the rights to ever protect their members and file grievances. That would be inconsistent with labor law.
Well, this goes back to, I think, a question that Justice Neyman raised, is that this seems like a very fundamental type of question. Has the association never tried to, has a trooper never sought to grieve a disciplinary issue before? Has this never come up? Why are we hearing this for the first time?
Because there was a just fundamental belief by the association that the department was correct and they weren't allowed to do it. And we decided one day, when I took over representation, that that is not how the law was read. So we're going to challenge that. And that's the simple truth.
Thank you.
Good afternoon. Dan Bernelli for the Department of State Police. The department's position is not that individual members, uniformed members of the state police, cannot challenge discipline by the colonel, whether they're a part of the association or they're a non-union uniform member. The position of this case is essentially the venue of where a uniform member...
You say it must go to the trial board and to the Civil Service Commission.
Correct. And
so I guess that begs this question. The overarching question is who gets to determine what constitutes just cause, right?
Correct.
Do you agree with your sister that just cause is different in arbitration than it is in front of the Civil Service Commission?
I would argue no. I think in both contexts, you get a de novo hearing, whether it's between an arbitrator or the Civil Service Commission. And I think...
Just cause is not defined in the CBA.
Correct.
Is it defined by the Civil Service Commission?
I would say in the evolution of civil service published decisions related to whether it be termination or suspension without pay, they're defining just cause. And my review, and I acknowledge that this is not part of the record, I do not see a distinction between the just cause standard displayed at the Civil Service Commission to where it would be displayed at an arbitration hearing.
Let me ask you this. Why isn't just cause, why isn't that a term of the CBA within the meaning of Article 22?
I would argue that the only reference to just cause is in Article 2, management rights. And I think to essentially, the union's position would be that, well, we don't agree that there was just cause. As a result, we can grieve a violation of Article 2. And I would suggest that that would essentially invalidate the purpose of Article 2. The most important part of Article 2, I think...
Gives the colonel complete discretion to deal with discipline as long as it's for just cause.
I would say that Article 2, it would invalidate it because the parties, what did they put into Article 2? It says, except otherwise limited by an express provision of the agreement, employers shall have the right to exercise complete control and discretion over, and it lists several things, including suspension, demotion, discharge, or any other appropriate action against its employees with just cause. There's no article related to the procedures for discipline in the collective bargaining agreement. There's no definition of just cause or discipline in the collective.
So what is your, am I right that your understanding of just cause in Article 2 is that it incorporates the procedures and protections of the statute?
Correct. If you look at the preamble to the collective bargaining agreement, they recognize the rights of the colonel in its enabling statute in 22C. And then I would also point to that the court, when it's a question of contract of whether something is subject to arbitration, is a question of law. And to use the language of the Watertown case, there are positive assurances that the parties did not intend for discipline to be part of the collective bargaining agreement. And we've referenced Article 37 and Article 36, but what I think is important about those articles is not just that the parties, when they wrote this agreement and agreed to this agreement, they didn't say, well, this article is not subject to discipline. If you look at page record 122, they put, and that's Article 37, this is on page 122 of the record appendix, will be subject to discipline in accordance with standard departmental procedures involving disciplinary matters and in accordance with the disciplinary authority contained in Mass General Law 22C. Also, they go on to say on page...
that was Record Appendix, Volume 1, page 122?
Yes, Article 37.
Yep.
And then on 123, they say, any employee refusal to a drug test, when directed, employee will be subject to discipline in accordance with statutory and departmental rules. That's Record Appendix 123. It's subsection 2, paragraph F. And that goes, it's the same language again is used on page 127. And Article 36, it says you can arbitrate any issues except disciplinary issues, and that's on Record Appendix 121. So it's not just that the parties are saying these articles, you can't grieve them if it relates to discipline. There's a recognition of the parties of the statutory rules related to discipline in the CBA. So
But,
when you,
I mean, let me pause you just for a second there, and this isn't fair because I'm just picking one of the things you said, though it's the most recent thing. If I look at Section 13 on Record Appendix, page 121, it does, as you said, accurately say, the association can process to grievance and to arbitration any issue as to the interpretation or application of this article, except disciplinary issues. If it were true, as you assert, that Articles 2 and 22 read together mean that disciplinary issues generally are not subject to grievance, why would Section 13, why would that sentence be necessary?
I would say because they are they're putting down the steps of what happens related to
Is this the physical fitness
yes,
one?
fitness for duty. So if you read of all of Article 6, it talks about setting the standards for testing, for the types of tests they're doing. So the parties are making clear throughout of Article 36, yes, you can challenge the manner of testing, the type of testing that is done, and those can go to arbitration. What can't go to arbitration are the disciplinary issues. So I think the parties are making clear in Article 36 that they're being consistent with any other type of discipline that is issued by the colonel. And I think the department would be in a weaker position if the CBA does not recognize the statutory rule, the parties, including the union, recognize the statutory rights in the CBA.
It would have been great had the CBA said Article 22 shall not apply to Article 2.
I wouldn't be here right now.
Or just cause means.
But then again,
as
we might not
provided.
have jobs if
Yes.
that was more clearly written. So I'm going to ask this one more time, and I know you've just covered this in some ways, but I'm going to ask you to give me the most articulate, explicit answer you can give. So Article 22 says, grievance shall mean any dispute concerning the application or interpretation of the terms of this CBA. My question, why is just cause then not a term of the CBA within the meaning of Article 22?
Because you still have to read Article 2, I would suggest, in the context of the entirety of it. It's not, Article 2 is not just the colonel may discipline with just cause. The context of the just cause in Article 2 is that it's within management rights. And so that has to be read together with the first sentence, which states, except otherwise limited by an express provision, employers shall have the right to exercise complete control and discretion. So if the court were to adopt the union's position, then that would essentially invalidate the purpose of Article 2. You have the purpose of Article 2 right in that first sentence. They can, if the union believes that whatever discipline is imposed, whether it be this case or any other type of case, that there wasn't just cause, they would then grieve and arbitrate it, which would then expressly limit the purpose of Article 2. It would turn it on its head. It would invalidate the need for that first sentence that the parties put in there, except otherwise limited by another express provision of this agreement. I would respectfully disagree with the union as it relates to their brief about the Falmouth Police Officers Association case from 2011. They said the facts are distinguishable from this case. And I would just point out that this court in that case reviewed the arbitrator's decision, and the issue in that case was the same issue here, that whether the ability to challenge a demotion or layoff was part of the collective bargaining agreement. And in that, the court noted that the arbitrator in that case found the agreement lacks additional language providing an election of remedies allowing a union member claiming to be demoted or removed without just cause to proceed either through the arbitration or before the Civil Service Commission. Union members may only address their complaints to the commission and do not have the option of proceeding to arbitration. This court in that case agreed, found there was no basis to conclude the parties intended to allow the grievance and arbitration provisions to be an alternative option for disciplinary actions. I would suggest, based on the language that is in the CBA, specifically the references to the statutory rights of the department, it's the similar case to the Falmouth case, that you can't find that the parties agreed to an alternative option for discipline beyond what was in Chapter 31.
In the case you just quoted from, is that 80 Mass App Court 686?
Yeah, 80 Mass App Court 833.
Can I have the site again, please? I'm sorry.
Yep, 80 Massachusetts Appeals Court 833. It's Falmouth Police Officers Association versus Town of Falmouth.
So, I mean, here's the problem for you with relying on that case, I think. The penultimate paragraph of that case says, ultimately, the arbitrator had to determine whether a mention of the party's adherence to civil service law imported into the agreement a just cause requirement. Just cause is a significant employment protection that should not be lightly imposed unless the parties have bargained it into their agreement. That happened here.
I would respectfully disagree because of the other references in the collective bargaining agreement to Mass General Law 22C, Section 13. In the same way that...
Oh, wait, let me pause you there, but don't forget what you were going to say. Are you saying that by importing or specifically acknowledging, or however we want to say it, 22C, that undoes the just cause mention in Article 2 or 22, I forget which one it was?
I do, because...
22.
Article 2.
Sorry.
I do, because the mention of just, of the statutory rights is not that the union employees cannot challenge discipline. The reference of the statutory rights is the venue in which they get to challenge those. And in the same way in the Falmouth case, they say, well, there's a reference to Chapter 31, and the parties agreed that Chapter 31 civil service is the venue to challenge these types of employment actions. It's the same thing in this CBA, where you have the parties recognizing the statutory rights of 22C, Section 13, as it relates to the disciplinary procedure. I would also note that in that case, the arbitrator noted that all prior challenges to disciplinary action have been pursued before the commission rather than arbitration. I tried to find any sort of grievance or arbitration procedure related to discipline that has proceeded before related to the CBA. I could not find any evidence that a union member has elected to grieve and arbitrate discipline and not elect to go to the Civil Service Commission.
And so that is, taking you at your word, that is persuasive evidence that the union did not previously act as if this was something, a right for which it had bargained. But I don't think that it is binding on us as a means of contract interpretation, which is essentially what we're doing here.
Oh, no, but it is past practice. And I would say past practice with the terms of the agreement, it can be used for persuasive authority. If it was an accepted practice to go to civil service by the union, it's then difficult to find that they didn't agree that they could implement in the CBA that they can't grieve and arbitrate discipline. So I think it's a compounding factor as it relates to the language that is in the CBA, which reference the statutory disciplinary procedure.
How do you address the state and federal principle, and I'm now reading from the Falmouth police officer case, but it's quoting something else, that where the contract contains an arbitration clause, there is a presumption of arbitrability, and now I'm pausing, skipping some stuff. Doubts should be resolved in favor of coverage. The presumption is successfully rebutted only if the party resisting arbitration shows either, one, the existence of an express provision excluding the grievance from arbitration, or two, the most forceful evidence of a purpose to exclude the claim from arbitration.
So I think, as I respectfully make clear in my brief, I think it's both. I think, one, you have Article 2, the first sentence that I keep referencing, except otherwise limited by an express provision of this agreement, employers shall have right to exercise complete control and discretion. I think that is the existence of an express provision that excluding the grievance from arbitration. And then two, the most forceful evidence of a purpose to exclude the claim from arbitration would be the other references to discipline in the collective bargaining agreement. I would argue that beyond the union's interpretation of Article 2, there's nothing in the collective bargaining agreement that would support their position. The other references to discipline, I would suggest, would support the department's position that it's statutory and not subject to the grievance and arbitration procedure. The last point that I would want to make as it relates to 150E Section 8, the divesting civil service jurisdiction if an employee elects to grieve.
Your time is up, but you can complete your thought. Go
I
on.
would just note the City of Chelsea case from the SJC a few years back, 491 Mass at 434. The opinion in that said arbitration under 150E Section 8 is the exclusive procedure only if the parties have agreed that the disputed matters are subject to arbitration. So there has to be an agreement before there's divestment of the civil service of jurisdiction, and if there was agreement, we obviously wouldn't be here today. So if there's no further questions, I would rest on my brief.
Seeing none, thank you. Very well argued, counsel.
Thank you.
The case is submitted. I'd like to thank the court officers, clerks, and all of the staff for their assistance this session, and that concludes our session.
Court all rise, please.